A very good afternoon and welcome from the African Construction and Totally Concrete Expo. My name is Kelly and I'm the Program Director and your moderator for today. Of course, I'd like to thank you for joining our second digital talk, which is supported and accredited by the SAIBD and SACAP. All attendees who stay for the full session will receive a CPD credit of 0.1, and we'd like to kindly request that you send your SACAP registration number to Zara Eccles. Details will be provided in the chat. Before we begin, please place all questions in the Q&A box and we'll tackle them once the speaker has concluded his session. This is a two-part session and our first speaker is SACAP's Legal and Compliance Officer, Ntanganedzeni Makakavhule, who will present on the Code of Conduct for the architecture professions. Thereafter, Videsh Boodu, the National President of the SAIBD, will tackle the identification of work policy. Ntanga, thank you.
Thank you, Kelly. Thank you for introducing me. And today we'll be discussing the South African Council for the Architectural Profession, the legal framework and the Act, basically. So it'll be based on the Code of Conduct and the Act. So in my screen right now, I'll just share my screen and then get a slideshow wherein we'll be taking it from there. So the South African Council for the Architectural Profession is under the Department of the Public Works and Infrastructure under the Honorable Minister Patricia de Lille. So in the under the Department of Public Works, we have 6 councils: the South African Council for the Architectural Profession, the Engineering Council, the Council for Project Management and Construction, the Council for the Quantity Surveyor, the Land Evaluation Profession. So the South African Council for the Architectural Profession has 7 members. It's composed of.
We do apologize. Ntanga seems to be having some internet connection issues. As soon as he connects successfully, we will continue with his presentation. We are trying to work on this. Apologies. While we wait for Ntanga, just a reminder to please send Zara Eccles your SACAP registration number to ensure that you will receive your CPD accreditation. Ntanga, have you joined us? I think Ntanga's internet has dropped. So what we will do is, to avoid wasting any time, we have got our National President of SAIBD with us on the call. Videsh was due to be on the second half of this session, but due to Ntanga's connection, I'm going to request that Videsh, if you are with us, perhaps it might be good to start on your end with the discussion on the identification of work policy. Hi, good afternoon, Videsh. I will leave you to it for the first half an hour, and as soon as we get Ntanga's connection sorted out, he will join us to continue his presentation. Thank you, Videsh.
Thank you, Kelly. I'm thanking the participants for attending, and welcome to the first DMG webinar. Obviously, this is a CPD accredited Category 1 event and accredited by SAIBD. As Kelly introduced and did say, I am the Vice President of SAIBD and the current CPD officer. So, welcome. Today's topic, and I'll be trying to share screen right now. Okay, so today's topic is the identification, or I got in brackets there, or reservation of work. And that is what we commonly refer to as the IDoW for the architectural professional. So I'm just going to dive straight in. with a few thought-provoking questions. What is the purpose of regulating the profession? And hey, I'm an architectural professional. I don't have the answers to that. The thing is that the Act 44 that regulates a profession doesn't have a preamble, which then obviously makes interpretation of the Act difficult. I think difficult would be the first or the easiest way to describe it. So I think we all need to put our thinking caps on and say, why are we regulating the profession? Only then can we go forward and say, this is how it should be regulated. You need a proper interpretation of why it needs to be regulated before we can decide on how to actually regulate it. Having said that, there's the current issue is the IDoW, which then stems obviously from the Act itself. And related to the IDoW is registration, because you have the 4 professional categories of registration and the 4 candidate categories of registration. Obviously, for now, the candidates work under mentorship, and therefore they can't really sign off, or they can't sign off their own work. But it still has an effect on the candidate. I'm talking about the IDoW will have an effect as soon as they become professional and going forward. So one of the things to understand from registrations and I'm going to call it the 4 categories of registration, because I'm going to concentrate basically on the professional levels, is progression. The worker or the workplace experience is a learning experience. I would say more so in our profession, the architectural profession. It is a learning experience. So you are improving all the time. Every time you take on a project, everything you do in an office or on site, from design to management, is a learning experience. And that needs to be taken into account for the progression, should I call it, or movement between the categories of registration. So competency. Competency is related to that experiential learning and formal education. When it comes to formal education, I'm going to quickly state the history behind education in architecture. From my research, again, I'm not an expert at this, I'm not an academic, but the formal education route is less than 100 years old. There are some nice articles written about it. South Africa was actually very key in formalizing education in architecture. Prior to that, and for thousands of years, education in architecture was via mentorship. The problem currently is that mentorship is not recognized. We've taken a new method. When I say new, less than 100 years old, and totally seem to ignore a method that had a tried and tested, and it worked, and it worked for thousands of years. So that is one of a criteria that's not taken into the IDoW. Yes, it is, in the sense that there is RPL, but we'll get back to that just now. The other issue is complexity, or building complexity. So remember, we have to take your competence and weight against the complexity of a building to regulate it. Complexities. You can get simple yet complex buildings, and you can get complex yet simple buildings. It's not dependent on size. For I can have a 40 square meter building that's really complex. It could be the use, it could be the environment. There's so many factors that influence the complexity. You could have a really large building that is not very complex. Again, it's dependent on many input factors. And I just quoted two earlier on, which is and the environment and its use. Impact to society or the neighborhood is another factor that needs to be considered. You can have a double-story house that's as complex as a single-story house. So just saying because it's double-story is more complex then is wrong, or should I say we need to redefine how we think of complexity. Then the question is, can professionals climb the category or the levels of registration? So, yes, there is RPL. The problem is RPL was initiated, withdrawn, brought back, withdrawn. It was always problematic. And I think, just for me, the root of the problem is that the fact that experiential learning is not actually taken into account, number one, properly. There's no university at the moment that actually looks at someone who had no previous or an incomplete qualification and adjudicate that knowledge gained and align it properly to a competency level. When I make that statement, also consider that a graduate that leaves 3-year or 5-year or 7-year study is just that, a graduate and not a professional. It is the workplace that makes them professional. Again, these are my statements, and a lot of people agree with these statements, and there are some people that don't agree with it, understood. But what I'm saying is we need to have an inclusive society where these ideas can be put together and a proper solution can be found. Exclusive societies never ever worked and always had problems. So very quickly, the couple of things is registration is highly linked to the IDoW, the levels of registration. Education needs to consider that experiential learning is a method of education and being competent. There is other issues, for example, what we call the missing middle in architecture. The missing middle in architecture are basically people that were registered prior to the compulsory date of registration. I think it was 2006. And then you have another set of people after that date to the current date, or till the date that the IDoW is going to be published. Where do they fit in? With regards, very quickly, with regards to the missing middle and the proposed limited special dispensation, there's been talk going around that professionals can only apply for limited special dispensation if they are principals of companies, and or if they do work till stage 6. There's a major problem with that, because then many people who are considered missing middle in architecture would not be able to apply, and even practice principals would not be able to apply, because the real world, if you go to Khayelitsha, if you go to Durban North, or many of the residential areas in Johannesburg, or anywhere in the country, 90% of that work does not require, or the client professional agreement stops at normally stage 4.2. It doesn't go further than that. So also consider that 90% of stages 5 and 6 work has been farmed out to other professionals, and it can be subbed out. So imposing these rules on the missing middle seems discriminatory, and that's now the end of my slideshow. There's a lot more that I could say, but looking at time, and before we go into Q&A, there's one other statement I think that's very important to make, and that is that without all the policy documents that relate to the limited special dispensation, recognition of prior learning, and if it's basically, if those policies are not embedded, I'm not talking about the philosophy, but the policy itself. If it's not embedded in the IDoW, it's open to, let's just say, it can be open to discrimination. It can be open to people not climbing or being able to do the work they are currently doing. And I'm going to stop there and look at if there's any comments. Kelly?
Thank you so much, Videsh, for your interesting presentation. I see we do have quite a number of questions, so just for the sake of time, I'm going to go with Garrett's question. Hi, Videsh. Who do you believe should draw up the preamble, and will they be fair?
I'm going to suggest that, well, someone needs to kick it off, and I would suggest that the architectural professional kicks it off, and not just, I'm talking about the whole professional. Maybe put it out there. What is the intent? And get ideas and collate that from the registered professionals at the moment before it can be expanded on or refined. Thanks.
Excellent. A question. Why is all the SACAP annual registration fees the same when different categories of professional registration can't do the same work as per the identification of work?
Very good question, David. And I can't answer that. Obviously, I'm not SACAP. But I would say that it is unfair to allow certain professionals to do work with high income and certain professionals with low income and demand the same registration fee. That does sound restrictive or discriminatory. Thanks.
Thank you, Videsh. One from Carlos. Hi, can a candidate architect be mentored by a professional technologist or senior technologist?
So I would say yes. Hang on, let me reread that question. Can a candidate architect? Again, I'm not speaking on. I'm not SACAP, so I could be corrected. But if you're a candidate professional architect, you need to be then mentored under a professional architect. If you're a professional draftsman, a candidate professional draftsman, you could be mentored under any one of the other 3 categories. That's how I believe it works.
Another one from Gareth. The identification of work as proposed now does have merit, but will require more definition in each field. I'm not sure how soon we will get there, though. We must never exclude those that are more qualified than those who have a degree. So I think that was more of a statement from Gareth than a question.
Can I just expand? Sorry,
Yes.
I need to hop in on that. And yes, it's a very true statement. What I do have to expand on, and I missed that out on my slide, trying to keep time in, is the fact that the tables, the restrictive tables in the proposed IDoW, does not align to the final year project. So just say I'm studying to be a technologist. The final year project, the project that I do in my final year does not align to the tables. And that is a problem because I'm studying to do something, but the tables or the regulation then says I can't do it. And that's where the discrimination and disparity seems to lie. So thanks.
Thank you, Videsh. What is the vision for the medium to long term for the architectural profession in terms of categories? Is the professional draftsman category going to be phased out? Currently, the draft identification of work is very restrictive for professional draftsmen. And irrespective of their experience, the identification of work attempts to address this, but seems very cumbersome. Commenting without having access to detail mechanisms for special consent or special limited dispensation on, and the RPL is currently on hold. The responses and the outcome from the call for comment from SACAP and the on the identification of work will be interesting to read. So I think that's definitely for you, Videsh, and possibly for SACAP later on as well.
There's a lot in that statement. Thank you, Dhiren. Yes, my feeling, and many, it's not just me, many of the people I engage with are of the opinion that we have too many categories. Again, those can only be answered properly if we know what the intent of the law is. Why did we create 4 different categories? What was the intent behind it? I feel that the number of categories of registration can be greatly reduced to 2, at the maximum 3. And again, thanks for the confirmation, Dhiren, but we need the policy documents to make proper comment.
Videsh, we have a question here from Peaches. The identification of work does not place any restriction on professional architects, but only on the remaining categories of professional registrations. As professionals, why would 2 separate controls apply to only 3 of the 4?
Okay. I wasn't involved in the drawing up of the IDoW. It's a very important question. Thank you, Petrus. And it's something that needs to be considered, because the other idea, again, if I had more time in my presentation, is that, for example, SANS 10400 Part L states that an architect or a senior architectural technologist are only allowed to design roof trusses, deemed to satisfy a roof truss, by the way. I'm saying that even technologists should be able to do that. And at the end of the day, technologists, and looking at outcomes, I mean, looking at a student that studied at a technologist level and a student that studied at architect level, the technologist level understands how to design a truss, or understands how to put together a truss. It seemingly, again, it's my observation, seemingly better. Understands the way the timber will bend and where it's under compression and tension, etc. better. I'm not saying, all I'm saying is that's what I'm observing, and that's what many people observe out there in the market, in real life. So there is some disparity. There's something that's drastically wrong with the way the IDoW is set up. So, thanks.
Thanks, Videsh. Do you have any information regarding the actual revised identification of work that could be implemented? I know you mentioned that only Friday there was some progress on this, so I'm not sure if you are able to give any more information on this.
Okay, that's your question, Kelly, or?
Actually, that's from Ingmar, excuse me for my pronunciation.
Okay, I'm trying to understand. On Friday, okay, I didn't make any public comments on Friday, so I'm a little confused there. An alternative method, yes, many alternative methods have been spoken about. There's many alternative methods done in other countries. Some countries actually don't have any restriction or reservations of work. I'm going to give depending on time, but this might take a minute or two. There's some classic cases in South Africa where there was no reservation of works in the past. I'm not saying we don't need it. I'm saying until the preamble or the intent of the law is clear, we then can make a decision. But for now, I'm saying from the late 80s till the early 2000s or middle 2000s, eThekwini municipality, or what we know as Durban, the old Durban city area, did not apply any restriction or reservation of works. There was a law, the Old Architects Act, which restricted work. There was then at that time only architects and non-architects, but it was free for all. That was based on a precedent from a court case. So the question to ask is, has architecture, has the built environment failed during that time? Then the next thing to consider, since about 2015 till current, there is no reservation of works. It's been withdrawn. The only restriction we have currently is the Code of Conduct. The Code of Conduct basically defining what work you can do. You do it yourself, right? And then the question then is, in real life, when we drive around and look around in our cities at the moment, it's gone 4 or 5 years now, has architecture failed? Has the built environment failed? Yes, there are collapsed buildings, we know that. Yes, there are. I'm not necessarily saying it's an architect, but has it failed? So when we draw up, or when we think about the idea of why do we need, what's the purpose of the controlling the professionals, we need to ask ourselves these questions. I don't have the answers. I'm just posing thoughts here at the moment. Thanks.
Videsh, I just want to tackle one more question before we move on to the second part of our session. Charles says that he has gone through the RPL forms, procedures, and this to him is restrictive and does not take into account what is practically happening on the ground. He says there should be room to also acknowledge that a person in a certain lower category can be exposed to complex buildings and projects and gain that experience to execute very effectively. What is your view on that?
Okay, so I'm also an RPL candidate, by the way. So I know the forms and I know it very well. There are problems with the way the RPL is done. There are. The automated process, firstly, there are problems with it. And I would very quickly advise, if you find, as an applicant for the RPL, if you do find that there are problems with the way the outcomes, the automated outcomes are, please write to SACAP. Because, yeah, you're getting almost negative results for positive stuff. I know it's closed at the moment, so you can't actually do an RPL application at the moment. But the old applications, those who did it, yeah, there were some problems. And yes, it is a bit restrictive, especially at the last stage, that is moving from senior tech to architect. That seems to be just based on data. No one's been able to seem to go through that level, or very few go through to that level. And I think it needs a total rethink. A whole new philosophy, should I say. So I can, before I hand over back to you, Kelly, I know you said it's the last question. I see a whole lot of other questions from some interesting questions out there, and I know we're restricted with time. Would these questions be forwarded to me, or can...
Thank you, Videsh. So what we're going to do now is we are going to hand over to SACAP's Legal and Compliance Officer, Ntanganedzeni Makakavhule, and thereafter we will tackle some of the questions that are posed for Ntanga specifically. We will then tackle questions that are still left in the question and answer box for both of you. Any questions that we are unable to ask, we shall email them through to you, and we will make that available for all attendees. So I'm going to thank you again, Videsh. We'll bring you on a little bit later. And Ntanga, welcome back. Technology, it seems, has been in your favor for the second half. So we'll allow you to talk a little bit more about the code of conduct for us. So thank you very much.
Thank you.
Okay, thank you so much, Kelly. Let's hope now it's going to be a lot much better than the previous time. So as SACAP, SACAP is a statutory body established in terms of Section 2 of the Architectural Profession Act number 44 of 2000. The council is composed of 7 registered persons who must represent the 4 categories of registration, 2 professionals in the service of the state, and 2 members of the public. The Minister of Department of Public Works and Construction is empowered by the Act to appoint the council. So the mandate of SACAP is that our mandate is to register professionals in 4 categories of registration. We have candidates also that we also register. We also accredited architectural learning institutions. We also consult with councils for higher education in relation to education and architecture. We also determine the registration and application fees. See, there was a question on registration and fees on it. We also keep a register for registered persons, administer SACAP affairs. So in continuation of our mandate is that we also protect the public and the professionals dealing with the registered, the public, we protect the public in their dealings with the registered persons. We take steps, necessary steps in the improvement of the standard of service and render registered persons. We also protect the built environment against unsound architectural practice. We recognize voluntary association. We determine the identification of work. We also formulate professional fees and guidelines, and also make rules with regard to any matter permitted by the Act and any matter that can better the execution of the Act. In terms of Section 17 of the Architectural Act, it says that the Council may establish a committee, including an investigation committee, to assist the performance of its functions, and may appoint any person as a member of that committee. SACAP Council performs merit functions through its committee. For example, the Education Committee, the Fee Committee, the Identification of Work Committee, the Stakeholders Engagement, the Investigation Committee, and also the Remuneration Committee. In terms of license to practice, the Act states that in terms of Section 18, subsection 2, a person may not practice in any of the category contemplated in subsection 1 unless he or she is registered in that category. So as per the registration categories, we have the professionals, architects, we have the professional technologist, the senior technologist, and the draftsperson. So if you're not registered in that category, so you are not allowed to practice. So that is one of the things that SACAP does to try and protect the profession, and also make sure that only registered persons are allowed to practice architecture. So in terms of Section 41, 1 of the Act states that a person who contravenes Section 18, subsection 2 is guilty of an offense. So if a person is practicing in any of those categories without being registered, is guilty of an offense. So in terms of Section 26(3)(b) and D of the Act states that a person who is not registered in terms of the Act may not pass himself or herself as a registered professional. So if you're not registered, you cannot call yourself an architect, a draftsperson, a technologist, or a senior technologist for that matter. We also have Section 26(3)(c) of the Act. The Act states that a person who is not registered in terms of the Act may not use the title referred to in Section 18 and 21 of the Act. The titles are registered for, the titles are reserved for registered persons only. So all those people who are registered in regard to those category of registration, those titles are reserved for them. But you might find, you may find, you do find people who are not registered at all, who are saying that they're architects, they're saying that they are, well, in any, whatever they choose. So for them, it is a criminal offense. They are contravening the Act. So we also have Section 27 of the Act. The Act gives us the authority to make a code of conduct, to formulate a code of conduct with consultation with the CBE and other voluntary stakeholders. So the registered persons are subject to disciplinary supervision of SACAP, the council. So it says that, yeah, it is an overriding obligation that in carrying out the registered professionals' work, registered persons are expected to act with due diligence, competency, and integrity. So the rules of professional conduct. The rules prescribe that the ethical principle and rules of conduct that all RPs are expected to uphold and be measured against. The rules set out values, principles, standards, and registered professionals have to adhere to when dealing with the public. SACAP takes great interest in the professionals' conduct and integrity of RPs. RPs will be registered professionals. In case if I have to repeat RPs, it will be referring to registered professionals. So in the current code of conduct, we have Rule 1, which deals with unprofessional conduct. We also have Rule 2, which deals with technical competency and professional work. We have Rule 3, which deals with promotion of services. Rule 4, which deals with professional responsibilities. Rule 5 deals with establishment of an architectural practice, and Rule 6, which deals with international work. On the rules of professionals' conduct, SACAP annually receives approximately 150 complaints. That's just an estimate of the number of complaints that receive on a yearly basis. The complaints against registered persons. There are some are against persons who are not registered, and then people who have been who have had their registrations cancelled due to failure to pay prescribed annual fees. So the majority of complaints are about the standards of the services. For example, poor communication, failure to comply with the building regulations, failure to do the work within a reasonable time, misrepresentation, where someone would be saying that he's an architect, where else he's registered as a draftsperson, copying intellectual work of another professional, where someone has taken some other person's work, fraudulent using municipal stamps. We find people using saying that the plan has been approved while it has not been approved, and they would have a stamp to put on the plan to show that it has been approved when in actual fact it has not approved. We also have complaints of professionals who are causing construction to commence prior the approval of the plans, wherein you can see that, okay, fine, these plans are going to be approved. Well, anyway, you can start with, but then the National Building Regulations state that you cannot start the construction without approved plans. We also have complaints wherein the registered professionals have changed the scope of work without the approval of the client or the public. We also have complaints on failure to set out the terms of appointment in writing, of which this one seems to be coming on a lot. There is we have on our website the terms of appointment, your contract, how your contract should be professionally. We try and make sure at every time that we get. That's why I'm probably emphasizing much on this one, because it is very much important for professionals to have a contract or terms of appointment which comply with the code of conduct, because it also protects you as a professional in the event of dispute that might arise during construction, if it's an appointment that includes construction, and also during the project, if it's from stage 1 to stage 4.1, a lot of challenges do happen. Challenges with your client. Some clients are difficult, and sometimes if you don't have a contract, it will be when it comes to SACAP, we want to treat it as if it is a professional. We don't, because it's much easier to have a situation where we are not dealing with he said and she said. There's a contract in place which states your scope of work, and then you have done what you have done, and then the client may be saying, no, this is not what I wanted. But then at least if you have something which says that, okay, fine, this is my work, this is what I've done, it's much easier for you to prove your case. But in the event that there is no scope of work, it gets a bit difficult for you to say you have done the work, but where is it in writing? So we want, and I urge all professionals to look at the code, to look at the website, look at what we have on the website as a contract, or just rather look at the code of conduct, look at rule 4.1 to rule 4.8. That's how your contract should be. So when you have those clauses on your contract, it protects you. It also protects the other party. So yes, it's very much important to have a contract in writing that complies with the code of conduct. So we also have cancellation of registration. In terms of the Act, Section 20, subsection 1A, Roman figure 3 provides that.
While we wait, if I could just ask Videsh, I'm just going to ask you 1 or 2 questions that you've got here. If I'm just going to ask you to join us via video.
Hi, I'm back.
Thanks, Videsh. I think you're saving Ntanga from his his internet issues. So I just want to find out from you, there's obviously quite an overwhelming amount of questions that have come in around the identification of work. So just to tackle a few, Bernie asks, hi, I would love to make use of the RPL option for upgrade and have been registered for 14 years in the same category. Will we see the RPL opening up anytime soon?
Obviously, SACAP is in charge of that. The VAs and we as professionals can push for it. I believe that it would be opening up, or it has to, if the IDoW does get published the way it is. It's part of the requirement in the, well, for now, I'm just going to call it the preamble. It's not worded the preamble, but the ideology behind the proposed IDoW requires that these mechanisms be put in place. I think that's all I can say on that topic.
Thank you. And then Sandy asks, can someone who has no formal education but works with a registered professional register as a candidate?
Again, I'm just talking from experience here. Yes, I've had many colleagues of mine that have done that actually. There is also a problem, just to expand on it and give a solution, there is a problem being that if you are not registered but working in the industry as a draftsman, as a technologist, and there's many people out there in the market that are doing that. That years that you have worked in the industry, whether it's 2 years or whether it is 30 years, does not count. So all that experience does not count. What does count is from the date of registration. If you have no qualifications, I think, I could be mistaken, but I think it is 3 years of mentorship required for you to then register as a draftsman. And then obviously more mentorship, more, and to climb the ladder. So thanks. I see Ntanga is back.
Hello, Ntanga. You're struggling today with your connection. It happens. We're going to allow you to conclude your presentation. Thank you to Videsh for being ever ready to answer these questions. And we'll allow you to conclude. Thank you, Ntanga, and thank you, Videsh.
Thanks.
Thank you, Kelly. Thank you so much. So yes, I was on the cancellation of registration. This will be covered in terms of Section 20. So it says here in Section 20, subsection 3, the council must issue you with a written request that your registration will be cancelled. So we cannot just automatically just cancel your registration if your fees are not paid. We will then have to, and then in terms of the Act, candidates, let's deal with candidates now. In terms of the Act, Section 18.3 of the Act, read with Rule 2.3 of the Code of Conduct, says here that a person registered in the category of candidate must perform work in the category of which he or she is registered under the direction, control, and continuous supervision of a registered professional who is entitled to perform such work. So a candidate cannot have any pecuniary interest in the practice other than in respect of bona fide remuneration for his or her services as a candidate. Thus, a candidate cannot engage in any other business other than that of a candidate. So the council's mandate also, the council is mandated to regulate the architecture profession for the benefit of the public. Also, members of the public are entitled to receive quality architectural services. Council is required to protect the reputation of the architectural profession by ensuring that all persons offering architectural services are registered and are in good standing to ensure compliance with the rules of the rules and regulation. that would be the end of the SACAP's presentation. And Kelly, we will then have to attend to those questions. I was not looking at the side of the Q&A, so you can just read them out to me, and then I'll try to.
Of course. And we've got Videsh as well, so we'll try to tackle all questions as much as we can with what time allows. Ntanga, is SACAP engaging with municipalities? Do they actually know how the process of obtaining approval on building plans work? That question is from Thomas.
Yes, municipalities, we engage with municipalities, and on a regular basis, we have municipalities also engage with us on. So we also engage with them. Should a member of the public or a registered person comes or emails us, emails us, and asks us to try and assist. Sometimes it gets a bit challenging, where you find that when on our side we understand that these plans could have been approved, but because the municipality has their own ways of examining the plans, so we can't really much interfere with what they're doing, but then we can advise as to let's say on how we understand.
Thank you, Ntanga. What is the reason, from Anonymous, what is the reason for firms to be registered when professionals in that firm are registered?
So we as SACAP, as the custodian of the profession, we must know which companies are performing architectural work. So that is very much important, because there are companies which we are not aware of. There are bogus architectural professionals, not professionals, but bogus persons who are purporting to be professionals. So we must know which company is performing architectural work. So in case maybe we have a person comes and says, no, I have a problem with this company, when we click on that company, if the person does not know who is registered at that company, we are able to say, no, there is John who was this company, was it John that you dealt with? So we can easier for us to assist the public in protecting the profession and the public.
Thank you, Ntanga. A question from Gareth. Can you briefly explain how you expect the proposal seal to work with regards to council submission?
The proposal, is it proposal seal?
Yes, proposal seal.
Okay.
Privy seal, sorry.
Okay, thank you, Videsh. So look, in Cape Town, it is they have a portal. So you, as a registered professional, you submit your plans on a portal. That's where they will find your plans, that were the ones that you submitted, and it makes it easier because only people who are registered can submit plans. So they have done something which, if it's possible, if the whole country can have that form of submitting plans, it can actually assist. It can also protect the professionals at the same time, because the work will not be stolen from them. You understand? So the other municipalities will come on board in good time, but at the moment we only have Cape Town submitting through.
Thank you, Ntanga. Can unregistered person ask a registered professional to submit building plans, and how is SACAP monitoring and controlling this?
So unregistered persons are not allowed to practice as per the Act, because there are skills that architectural professionals have. There is an importance for having those people who are registered to perform that work. So if you are working with someone who is not registered, and you have to and you've been asked to put your registration number there to submit, the problem will come where there's a problem with the plan. Because when we engage with the municipality, what we are going to find is that we are going to find that you have inserted your registration number on those plans. So we will be dealing with you. So you, as a registered person, you must protect your number at all times. I know it's a bit difficult at times, but it is important that you protect your registration number. So should you be working with an unregistered person, you must inform the council, because it's a misconduct in terms of the code of conduct. You must inform the council that you are working with this person, and the council must then find out why are you working with this person who's unregistered. So if the person is eligible to register, then we would register the person in a category that fits that person's registration.
If there's time, can I add, Kelly?
Absolutely, Videsh, absolutely.
Okay. Thank you. What Ntanga says is so true, and at grassroots levels, you know, engaging with people in the industry and clients throughout the country, this is an ongoing problem. There are professionals that actually don't do architecture, that have people coming to them and to sign off work. This is the problem. This is what creates unprofessional professionals. It's bringing dispute to the industry. And I advise any professional, any of those professional brothers and sisters of mine out there, if y'all are doing this, to start questioning what y'all are doing. And I really encourage y'all not to do this. So yes, thank you.
Thank you, Videsh. Again, there are a number of questions coming through, so we will try our best to answer all your questions. Should the time run out and we not get to your question, we will send you the answer from both speakers towards the end of today or the week, if depending on the amount of questions that are still coming through. Just to continue, you know, there's quite a few questions around the cost of CPD. And if SACAP is aware that sometimes professionals can't do these courses simply because of the cost attached to it. Without, of course, you know, boasting our own events, the African Construction Expo does offer free CPD accredited workshops at our live show next year in 2021. So please take extra time to look at our websites after this webinar. Shamal is asking, what is SACAP doing about, apologies, Videsh.
Yeah, sorry, that is a very pertinent question. I don't know if Ntanga has anything to say about that, but as a vice president of a VA, as a CPD provider myself, and as an attendee to other CPDs, there are CPDs events out there that are ridiculously priced for the knowledge that it presents. That is a problem. There are CPDs out there that basically are have 1 or 2 credits attached to them, and when you actually attend, some of them are free, by the way. It's valued as a CPD officer, I would say, is valued at 0.5, but they're giving away 2 points. Then you get the very expensive one that again is overvalued and either overpriced and overvalued, or overvalued and underpriced. And the point being is, attendees or the people, the professionals here, choose your CPD provider very carefully. And I encourage SACAP to keep a much closer look at CPD. And lastly, as someone who attends a CPD, if you're not happy with the content and the education received, there is a way out. You can immediately or within a reasonable time address this to SACAP. It's written into the rules. into the CPD rules. You can address it to SACAP and write your complaint out. So, yeah, thank you.
Thank you, Videsh. Is it possible for me to be registered with SACAP but be based in another Southern African country and receive mentorship from there, from Anonymous? Ntanga.
The last part, yes. The last part, you can be registered anywhere, and you can be registered with SACAP and be anywhere, as long as you follow what the SACAP requirements are. So if you are in let's say in Zimbabwe, for interesting, as long as you are submitting your multi-training records and then you have met the requirements to be registered as a candidate, then you can, because we have professionals who are working outside the country who are registered with SACAP.
Thank you, Ntanga. Videsh, a question on the identification of work. It's caused quite a debate in our chat. Through the identification of work, how can we speed up the process of infrastructure delivery without taking long from all bodies and stakeholders? A question from Banele.
Sorry, I don't have the question open. Can you repeat the question so I can contextualize it properly?
Yes. Through the identification of work, how can we speed up the process of infrastructure delivery without taking long from all bodies and stakeholders?
Okay. So if you're talking about infrastructure, most of okay. I'm saying the IDoW and the question, or the link between the IDoW and infrastructure delivery. I'm basically trying to say there is a link, but the link is very, very thin. I think it's more important to say that if you want increased service delivery, allow people who are competent to do it. And the measure of competent at the moment, and the way the IDoW is proposed, would prevent many competent people, or people that can be considered competent and professional, from actually doing that work. So how do we use it? I'm not sure. I'm saying that is normally public works, and public works currently, I and many people like me are not allowed, or would not be allowed, to do work for the National Department of Public Works. And that's what the problem is. There are many competent people that are allowed to do the work. So I think it's more to do with economics and an equitable, an equitable share of the available work. That's what the problem is. I think, I don't know if I'm going on too long here, but Kelly, just remind me, but I think that the whole issue is reservation of works is not so much a competence issue, but a issue of, I don't know if these words will be correct here, an old boys club, classism. Those are the words that just click to mind at the moment. And income disparity is to keep the wealth within a certain grouping of people. I'm all for equality, qualified by the word equality of opportunity, not equality of outcome. Equality of outcome will destroy society. And the IDoW tends to lean towards an equality of outcome and not an equality of opportunity. I don't know if I went on too long there, but that's a whole day's talk.
Thank you, Videsh. Thank you for answering that question. Ntanga, why is SACAP not pressurizing the country's councils to innovate with their submission process like they do in Cape Town?
We are trying on a regular basis, but you see the efforts that SACAP can do, they can only go as far as another person who will then have to implement, because some municipalities have challenges, and not only challenges outside the municipality, but also challenges in the municipality. You find that sometimes we have situations where some building control officers are the ones who are submitting plans for the municipality, or for the members of the public, who you might find that they're not even registered firstly, or if they're registered as candidates. So when you have to engage with them to then do what they should be doing, then obviously they're not going to proceed with our requests. The same as when we have situations where we find that there are unregistered people practicing architecture, because we engage with the police. We now and then have to communicate with them that this person is not registered, and then those are the kind of the challenges that SACAP has. But with good governance, everything can be sorted. So we are in consultation with them, and it would be very good for SACAP if actually we can achieve that, because only because we want a situation where the professionals are at ease, knowing that the work is only done by them. And by them, we mean the registered professionals. And by it being them, it means that they would not be like there'll be more work for them, you see. So, but if they still Tom, who's not registered, and Sbu, who's not registered, submitting at the councils, and then you have Tom also, who's at the municipality, and Sbu, who's at the municipality, working at the municipality, and they are not for them it can be money, because they have people that are coming to them to say, no, can you please do this plan for me? So if we can eradicate those elements, I'm sure SACAP can be in a better, we can be dealing with better challenges than the ones that we have currently.
Thank you, Ntanga. So we have 5 more minutes left. A question from Joanne. How can architects' certificates be protected from being used by previous employers after you have left that company? She has seen employees have left the firm, and the firm is still using their certificates for tender purposes. One can't exactly refuse with their certificate when joining a company. What is your take on that, Ntanga?
Well, obviously, that's firstly professional misconduct on the part of the firm that is using the certificate, and secondly, it's fraud, because it's a criminal offense, because you are misrepresenting yourself to gain a tender. You understand? So in that event, if you have that kind of a challenge where you have left the firm but they're still using, because most of the complaints we have, like we have. There's not much new. There's nothing which is really new, because we have had this kind of complaints. So we deal them accordingly. If you have that kind of a complaint, submit a complaint affidavit to us, instruct us what is the problem. You have left the company on which date. If you have evidence, conclusive evidence, like you can show us that there's a tender which was there's tender documents which you submitted with your certificate. Submit that to us. We investigate, and then we can give you peace, because it's not, it shouldn't happen in that way.
Thank you, Ntanga. Before the webinar ends, I just want to thank everybody for their questions. A reminder that we do want to answer your questions, and we know that they are important to you. These questions will be sent to both Videsh and Ntanga after the session, and they will answer it as soon as they can, and we will share it with you. Videsh and Ntanga, thank you very much for your time this afternoon. Videsh, I think the identification of work is a very important topic, likewise Ntanga, with regards to the professional code of conduct. We remind you that this session is recorded, so you will be able to view it in the coming days. It will be available on our website. If you have not done so already, please send Zara Eccles, my colleague, your SACAP registration number so that you can gain your CPD points for this session. And I'm not sure if there's any sort of Other questions that have come from the audience, there were 65 in our inbox, but we will of course tackle them in the coming days. Thank you so much, everybody, and I think that this topic will be continued, as it's definitely something that's caused quite a stir with our audience today. So thank you very much on behalf of the African Construction Expo, and we thank SACAP and SAIBD for their support and their time. Much appreciated. Enjoy the rest of your afternoon.
Thank you.
Thank you.
Bye.
Thank you.